So good afternoon, everyone. Sorry to interrupt the wonderful lunch table conversations, but we're going to bring the session. We're going to begin the session. So my name is Nagai Pindell, and I'm the Dean of the Allard School of Law. And I want to begin by acknowledging that the Fairmont Vancouver Hotel is situated on the traditional territories of the Musqueam, Squamish, and Tsleil-Waututh peoples. I would also like to acknowledge that many of you are joining us today via Zoom from other places, near and far, and I acknowledge the traditional owners and caretakers of those lands. So thank you so much for joining us here today for this important conversation on AI in legal practice. It's the second in a series of events that the law school plans to host on this important topic. And as I'm sure our speakers will attest, this is a complicated issue that is new to many of us, but is increasingly becoming more and more part of our professional and personal lives. Beyond the extended classroom, so as the development of and adoption of AI continues to accelerate, law schools face the particular challenge of preparing students to respond to these new opportunities, as well as the risk posed by AI, as well as other emerging technologies. What we've tried to do at the law school is to think carefully and to think towards the future, to what this will mean for our students as students and in practice. We've recently launched the Allard Law program on law, technology, and society. This was made possible by a generous gift from the Gordon B. Shrum Charitable Fund. And it's a new initiative focused on technology, law, and society that will advance the law school's work to, I hope, future-proof legal education. And more specifically, the initiative provides resources for teaching, research, as well as multidisciplinary collaboration. One of the leaders of this initiative, John Festinger, he spoke at our most recent event in this series, and some of you might have attended either in person or online, where technology and the law intersect. John is an expert on law and technology who's taught courses on topics including digital media and video game at Allard Law since 1992. And in the spirit of interdisciplinarity, he's launched a course that explores the impact of AI on law and society, issues in regulating AI, and the use of AI in legal practice. And so beyond the extended classroom offerings that we have planned for this program, the program will also support the work of Allard Law faculty who are doing collaborative and interdisciplinary research into law and tech, tackling issues such as criminal justice, intellectual property law, and e-commerce. And as much of you are thinking about AI in your practice, I'm assuming many of you are lawyers in Vancouver, we're also tackling those same questions as academics and professors in the law school and in the university, how we teach students better with AI, understanding both the risks and opportunities, how we use AI for our own research, and how we think about how it can enhance both legal education, as well as the skills that new law students will bring to practice and those expectations, what practice will expect of the students to know about legal research and the possibilities of AI, and as well as what the students are able to contribute. So very exciting avenues ahead. And with that in mind, I'm very pleased to introduce our moderator, Associate Professor Graham Reynolds, who in his previous role as Allard Law's Associate Dean, Research and International, was integral in establishing the Law and Technology program I spoke about just a few moments ago. Graham teaches and researches in the areas of copyright, intellectual property law, and intellectual property and human rights. I could say a lot about Graham. He is a very accomplished student, having studied under a Rhodes Scholarship, a very accomplished teacher, having won the law school and the university's most distinguished teaching awards, as well as a very accomplished scholar. This afternoon, he's going to be a very accomplished and engaged moderator. And with that, let me call Graham to the podium. Mr. Gap.
Well, thank you for that warm welcome, Dean Pendel. I'm very excited to be with you here today. A little bit of housekeeping before we begin. So on the table in front of you and on the slide there is a QR code to access the Slido platform. So you don't need to download an app or log in. You just need to access the Slido event page and use the password AI and Law to submit your question. You can also upvote questions that you think are interesting. We'll save about 15 minutes at the end of the conversation to tackle questions. I'm really thrilled to be sharing the stage with our two panelists. Our first panelist, Michela Fiorido, is a partner at Harris & Company LLP. Her practice focuses on access, data security, and privacy law, with an emphasis on delivering a wide range of privacy training, representing clients in proceedings before privacy commissioners, and assisting clients in navigating access requests, data collection, and emerging technologies in the workplace. Michela is called to the bar in both BC and California, is recognized as a Fellow of Information Privacy and a Master Access and Privacy Professional, and is a Certified Information Privacy Manager. She's currently the chair of the CBA BC Freedom of Information and Privacy Law section. Having graduated from the Peter A. Allard School of Law in 2014, she treasures her role as an adjunct professor teaching the Access to Information and Privacy course, where she appreciates the opportunity to give back to the community and generate excitement among students in this evolving and fascinating area of law. Our second panelist, Allard Law alum Jen Luther, has built a career at the forefront of technology, ethics, and law. As head of product, privacy, and policy legal at Superhuman, formerly known as Grammarly, Jen leads global legal strategy for one of the world's most widely used agentic AI platforms with over 40 million users. Previously, she served as Deputy General Counsel and Head of Privacy Legal at Atlassian, where she architected privacy, ethical AI, and data governance strategies supporting the company's rapid international expansion and $120 billion market capitalization. A licensed attorney in both BC and California, Jen is deeply committed to advancing responsible AI, mentoring emerging legal talent, and giving back to the community that shaped her career. She serves on multiple advisory boards focused on privacy, AI ethics, and social innovation, and is passionate about helping the next generation of BC lawyers navigate the evolving intersection of law, technology, and society. So our conversation today will explore the practical, regulatory, and governance implications of AI for the practice of law. We'll look at the use of AI from both private practice and in-house perspectives. We'll also hear our speakers reflect on broader issues, including their views on responsible and effective AI adoption in the legal profession. So we'll get started with the conversation. And as a reminder, please submit any questions that you have through Slido, and we'll leave time at the end to answer many of them. So I'll shift now from this podium area to those very comfortable looking chairs, and then we'll get started on the conversation. All right, so now welcome to the next part of our And so, Michela, we'll start with you. How does AI show up in daily life as a lawyer in private practice?
Yeah, so I'll say I've never been so busy in my privacy lawyer life as I have been lately, and that is largely attributed to AI. How many of you have felt personally victimized by an AI self-rep or a client using AI? Okay, not alone. This is a new skill that lawyers are having to develop, and we're having to navigate this new terrain in dealing with these self-reps and with clients who are using AI in interesting ways. So very recently, I had a client who put one of my privacy policies into an AI application and then told me everything that was wrong with it, saying that I needed to refer to different legislation that didn't even exist, et cetera, et cetera. And AI aims to please. It tells you what you want to hear. And this client wanted to hear something wrong with this policy. And in this case, I told, the client was told that my policy was deficient. So when I get an email like that listing, it was very long, every line that was wrong in my policy, you panic. You're like, oh my God, did I do this? When you really get down to it, the term that we all talk about now is AI slop. That's all that email was. And I knew that ChatGPT was used because the client made a lot of references to operational misalignment and the conflation of compliance oversight with operational execution. And I'm like, ma'am, this is a daycare in the suburbs that you're running. Like, you don't need this. And I didn't call her out for using ChatGPT, but I did go through each issue that was identified to explain why she was incorrect. Her bill was very high, and so unnecessarily so. It was so unnecessary for that to happen. People have a lot of trust in these tools. You need to trust yourselves as lawyers, and people still need to have that trust in you, because AI is not currently as good as you and is never going to have that discernment. I don't think it's ever going to be at that level where it is a functioning human lawyer. And so, even when we use AI, we have to check ourselves too. Like, you can't just trust, like, you second guess yourself, like, oh, it's saying something different. Trust yourself. So, you have clients that are using AI, and then with the self-reps, dealing with self-reps who use ChatGPT to write these communications, it's frustrating, time-consuming. It can seem unwieldy. It just keeps coming. It can also be a bit creepy. There's something about the tone of ChatGPT. It's, it could be too cheerful sometimes for the situation, too submissive. Other times it could just ramp up to unhinged levels of aggression that you just, like, no human would ever write this. And so what do you do when you're faced with a bombardment of these types of communications? It's not just lawyers that have to deal with this too. I moderated a discussion recently with the BC Privacy Commissioner in January, and this topic came up, and he said that the OIPC, they're actually struggling in dealing with this as well, because they have to weed through all of these generated submissions and communications and requests for records and requests for corrections. And so this has the effect of, it's a great time and expense, not only for the OIPC and for public bodies, but on the other side, it is also seen as an access to justice tool for people who are exercising their rights for free with guidance from this technology. And so I don't know what the solution is there, but I do have some strategies to help lawyers deal with these types of self-reps. So, it's wild to think that this has happened so much in my career that I've developed a bit of a system. And the trick is, honestly, to be as boring as possible, write as little as possible. Don't take the bait, do the bare minimum to meet your compliance obligations, but, be very matter of fact, procedural, neutral, refer to the legislation, refer to your obligations. You don't want to get into a never-ending loop. You want to try and slow down this train. Like, they're expecting responses right away, and the time it takes you to write a response, imagine, like, they just tell ChatGPT, tell me what to do, and they've got pages and pages of content. Like, how are you going to keep up? Slow it down, not to the point where you're not complying, but, at least in the OIPC sphere, you've got 30 days to respond to a request for a correction, 30 days to respond to an access request or a complaint. Like, use up that time. You don't need to be, on this cycle. So slow it down. Don't feel forced to answering, they're going to ask a lot of questions in these communications. Don't feel forced into answering every single sub question that you'll get in one of these communications. Only answer the ones that you're obligated to respond to. Keep it very simple, and be very, reasonable, a matter of fact. Keep it as small as possible. These communications might end up before a tribunal or the OIPC, so you want to kind of show that you're being reasonable, and know that the OIPC is dealing with this as well. The Human Rights Tribunal is dealing with this as well. It's not just us having to grapple with this. So, yeah, that's kind of how it's been showing up for me, just like, and practically dealing with clients and self-reps using this technology.
Thank you. Yeah, and so it's interesting to hear that private practice perspective. I imagine that there are some similarities, but also some differences from an in-house perspective. And so, Jen, I was wondering if you might be able to share some key considerations for in-house counsel advising on AI products, or maybe also the procurement of third-party tools.
Absolutely. So I think one of the differences is that when you work at a technology company like the ones that I've been working at that are creating and deploying AI, as well as procuring and partnering with other AI tools that will integrate, you can't really say don't use it, or, anything that you do to sort of jam up the system of AI is going to be viewed as counter to the business's intentions and sort of product strategy. So it's a lot of like moving with the current of the capabilities, as well as doing a lot of really principles-based risk assessment. So I think, just my heart goes out to you dealing with all of the back and forth and like sort of the tactical fighting with different AI slop. In my case, a lot of it is more like taking a big step back and creating like tiers and categories of risk to quantify what sort of AI issues to spend most of your time analyzing. Because frankly, when you work at a technology company that has thousands of employees and your product roadmap is marching along and you can't really get in the way of that as a lawyer, you really have to think on your feet about how to be nimble and catch the things that need most attention. So we call that like a RAG framework. That's terminology borrowed from the software engineering world, and that's red, amber, green. So we sort of try to define policies or scalable resources for our teams to think about the red, amber, and green buckets of risk. So for an AI technology, we might say, if we're building it ourselves, you're green if you're not using any personal information, if you're only using behavioral and event data, things that can't tie back to an individual or don't present a lot of risk. And you want to do something that's within the scope of our existing contracts, privacy policy. Like we've already told people we're going to do stuff like that. You're not really using sensitive data. You can go ahead and do it. You don't need to come to the legal department for a big talk. Amber might be something that's a little bit more fringe. Like it sounds like something that we're doing already, but it might have a different spin to it. It might trade on a different source of data than was previously described in our policy. And then red is sort of like, we don't even know if we're going to go there. Back in COVID, some things that hit that red category for us in-house were like spying on people at home to make sure they're working. So like not just key logging, but like, oh, we want to see people's home office so that we can see who's in the office and are they there or whatever. And we're like, why? Like that is so disproportionate. Like it would be very hard for us to sit in front of a regulator and explain with a straight face why we need access to someone's webcam for the entire workday in the off chance that 2% of the workforce is phoning it in. So I think really thinking in those categories helps us move quickly. The same is true for vendors, but this one is a little tougher because as you probably all, I don't need to tell you, you've all noticed too, AI companies are popping up like daisies every day. Everybody's got some new technology that they want everyone to deploy. And unfortunately, or sometimes for the best, these teams are moving really fast. They're really small. And the chances of them having, like, let's just say an adult in the room or a lawyer in the room is pretty low. So we get a lot of requests from teams, especially in engineering and marketing, that are like, oh, there's this shiny new thing. It's going to solve all of our problems. Like we're going to be able to capture a new audience and sell into a new market if only we can use this small tool. Well, that small tool is taking in all of our customer lists, a lot of sensitive information. It might be automating a marketing workflow, so actually sending out messages and outreach on behalf of the company. And that's really hard because again, you want to make sure that you're enabling the business to do what they need to do. You certainly don't want to fall behind the market, which is moving very fast, but you do need to be thinking about not ending up in the front page of the newspaper. And that can be a really hard balance to strike. But again, I think it's that same principle of red, amber, green, but it's more around the maturity of the vendor that you're interacting with. So is this in the area that I live in now, is this like two kids in a garage in Palo Alto built this? Or is this sort of like an offshoot of a larger company that's got, just a new product line? And what we tend to be most comfortable with is if the company is offering something new. So if we already have a relationship with Salesforce, they've recently acquired another company that does something new and different, we can tweak the contracts that we already have in place. But yeah, it is a struggle to sort of keep the builders busy, keep the line moving while catching what you need to.
Thank you. And so I think both of you have spoken about how to respond by the use of AI by others in terms of your own practices and your own work, whether it's self-represented litigants or whether it's with other colleagues in-house wanting to use certain AI tools. Are there certain strategies that you have for adopting AI responsibly within your own practices? I think in some ways this builds on the RAG discussion that you mentioned, but or maybe how might you recommend using AI as a tailwind? I understand that's sort of a term that's used to describe kind of responsible use where you can leverage it to accelerate your work and increase productivity. Would you mind sharing some of those ideas with our group?
Sure, I'll go first.
Okay.
So as a privacy lawyer, I think maybe I'm have a particular level of paranoia, and I know that AI, you're encouraged to use it. It can help with efficiency and things like that, and I don't want to fall behind. When I use AI technology, I've tried it out for research. I found it to make up cases, especially in the privacy sphere. I don't find it that effective, and then when you point that out to the system, it'll say, "Oh, sorry, you're absolutely right. It won't happen again." And then it gives me the same wrong case again. And so I don't use it for research yet. Where I do find it helpful in my practice and where I'm comfortable using it is in policy drafting, where you're trying to capture all the different types of information that you need to identify in a policy that's going to be collected, or the purposes. It's very helpful for that, just to make sure you're not missing anything. But it is, you still need to be discerning. You still need to, read it all. When I taught access information at Allard last semester, we had a policy drafting assignment. And I encouraged, students are fine to use AI, but you need to, this is a part of our world, but you need to read what you're taking from that and really think about what you're putting in your policy, because it was a policy for a fake restaurant and people were collecting blood type and genetic data. So you still need to read what the output is giving you, but it is helpful for policy drafting. I use it for brainstorming. It's pretty classic use. Presentation titles and things like that, especially for presentations. If you've got general information that you want to talk about and it's already vetted and you put that into the algorithm, it can give you bullet points that you can put on your PowerPoint slide so people don't have to read a very densely populated slide if you're not skilled at doing that. That's a helpful use of it. I also struggle though with that because then it uses your good data to train the model and get smarter. And so I struggle, I'm helping this system and I don't it's a bit of a moral conflict because it is providing information to people. It is an access to justice tool, but you're also making it smarter to the point where people will trust it more, but it's never going to be as good as you. So I don't know if that's helpful. I feel the same about adding my own blogs and content about privacy to the internet, because then, a lot of the generative AI are using other firms' blogs and information to spit out content for people. And so it's just an interesting thing to think about. And then, it can be used for trivial things. I used it the other day to brainstorm costume ideas for the lawyer dodgeball tournament coming up. So it came up with some good ones for that. But that's how I personally use it. Just the privacy issues are too immense for me right now to use it for anything other than those things.
That's really interesting to hear your journey. I mean, I guess I could frame my thoughts as well in terms of my journey, how it started and now how it's going. How it started, not great. I was very sort of anti-AI, frankly. I'm a human rights lawyer by training. And so the fundamental rights issues involved with deploying AI systems across the world and the universe of information on the internet gave me a lot of pause. But my personal value is that if I'm going to criticize something, I should know it first. So my first foray into AI was taking one of the self-driving cars in San Francisco from the dentist home. It was the shortest trip I could take because I was pretty scared of getting in a car that drove itself. And that one car ride just amazed me so much that it's my preferred mode of transportation now. So when I started, I was very fearful. I was working at Atlassian. We're a B2B enterprise SaaS company trying to work with regulated customers. So banks, financial services, hospitals, educational institutions in Europe, in Germany, one of the most, conservative privacy jurisdictions in the world. And so we had formed an ethics committee because there were many of us who were interested in AI. It was just sort of a sparkle in the eye of our product team, but we could see that it was coming. And so we thought, this isn't going to scale well if we wait to react to the product roadmap when it has AI baked into it and we've got a month to act. Let's start early. Let's create an ethical review committee. We'll be cross-functional, but we'll operate in a very lean way. And let's come up with a set of responsible innovation principles that are approved by our senior leadership so that we don't, once the rubber hits the road and we've got test cases to review, we don't end up, in a crossfire of, the marketing team saying who agreed to this and so on. So we got stakeholder buy-in to really think about that from a principled position. And what I had the privilege of watching unfold from there was a really beautiful community that thought deeply about how to adopt and deploy new technology without sacrificing on the trust and sort of fundamental rights, like I said, that we all hold dear. So starting from my journey of taking that one Waymo to now, I use AI all the time. And I would have thought, just squinting at it from like a professional ethics perspective, that would be a complete no-go. I would have thought lawyers would be the last people to use AI. We shouldn't do it. We've got client data. We've got sensitive information. What about the Patriot Act? Like, all those kinds of things were coming up in my mind. And I had the privilege of working with some really wonderful colleagues who challenged my thinking on a lot of that. And we're like, well, why not? Like, could we use test data? Could we use dummy data? Could we feed into a system like ChatGPT, not like raw client information or the actual fact pattern, but could we abstract it to a point where you're saying like, there's a person who has this thing going on, and there's a product that you want to create that has this kind of thing. What would be some of the issues that you would think about? And there are also tools on the market now like Harvey that are actually trained on case law, and it's not like general survey of the internet type information. They're more specialized for our industry. So I actually use AI all the time now in practice. Like how it's going today, it's not perfect, but I use it in a variety of ways, as do my teammates on a daily basis. So some examples that I can give are like challenging a customer's contract. So if a customer would say like, oh, we want to redline this agreement and we want you to accept like these unreasonable indemnity terms, and the sales team saying like, we really want the deal, we really want to accept this indemnity clause, you can say to AI, give me 3 reasons why, or 3 examples from the real world of where a company agreed to this type of language and it blew up in their face. And it's pretty good at giving you, again, publicly available information on like, here's a few cases or a few decisions where this played out in an unfavorable way. Another way that we're using AI is for M&A due diligence. I know that sounds really scary, but to Michela's point, like, I wouldn't encourage folks to just use AI blindly, like especially where things are sitting today, especially if you're using it in an area of law that's unfamiliar to you. I think that's a red flag. Like if you cannot sanity check the output, don't use it, because then you just have no idea. You're just shooting in the dark. But for something like M&A diligence, when you have like a huge trove of documents in a data room, AI is very good at pattern recognition and printing out a beautiful chart. It can take your internal policies and compare those against like what's in the data room, tell you what the disparities are between the acquirer and the target. And if you have the expertise on your team, you can look at that output. You can say, these are the areas of most concern. I want to double click on those, and that's where we're going to spend our time, but not on the piddly little things that don't seem as important. Another one that I use quite a bit is competitive intelligence. So we were updating our privacy policy. And one of the things when you work in-house, for those of you who don't know this, a big pressure you get is to be market. Everyone wants to be market. We don't want to make like the most conservative privacy commitments to our customers because that will hamstring our product roadmap. We'll make unnecessarily big promises about we will never use data for this purpose or that purpose. But the technology is evolving so fast that making those types of evergreen commitments and taking a really hard line in this moment, I think is unwise. I think what will happen is you'll end up making a really hard line commitment that you can't honor 2 years from now for very good reason. So what I've been using AI to do is say, look at this list of 15 competitors in our space. What commitments do they make on these types of privacy topics? Who is the most conservative? Who is the loosest? And what sort of media would you attach to those positions that they've taken? How's it landing on Reddit and those types of things? And you can get, again, a very beautiful chart that's like where you might stack up in your industry as compared to your competitors. So I guess the last thing is a lot of thought partnership and brainstorming. It's really good for HR issues, I have to say. Like if you have a team management issue or you want to figure out how to develop talent in your team, really good thought partner for those types of things too.
Thank you.
Yeah.
So one topic that seems to have come up a lot is questions around privacy. Michela, I know that one of your main areas of expertise is privacy law and privacy compliance. And so I was wondering if you could speak just a little bit about some of the privacy issues that using AI raises, as well as how lawyers can use AI in a privacy compliant way and conduct effective due diligence on AI service providers.
That's a lot for
Do you mind answering all of those things?
In 2 minutes or less.
Yeah, in quite a concise way.
I'll start, like there's so many privacy issues that I think it's best to just start at the very beginning. Like, what is your legal authority to do this, to collect and use data? When you think about that in the context of how you would traditionally assess other technologies like surveillance, or computer monitoring, or whatever it might be, when you think about what is my legal authority to put somebody's personal information, because this comes down to privacy issues are raised when there's personal information involved. How do we do this in a way where we can put somebody's personal information and that's acceptable under the relevant privacy legislation? So we'll just talk in terms of PIPA and FIPA. If we're talking about PIPA, you need to have consent. Or if you're putting employee data in there, it needs to be for the purposes of managing the employment relationship. Okay, you could get there, but there's also an overall reasonableness requirement that you have to meet. So is this reasonable in the context of the type of vendor that you're using? There's security measures that they have in place, what they're going to do with the data. Like, is this a reasonable trade-off for what you want to do with the data? That's private sector. In the public sector, the information has to be directly related to and necessary for a program or activity of the public body. That's your authority to use this. Is it directly related to a program for you to put somebody's personal information into an AI tool? It could be. It could help you with efficiency and things like that, sure. And is it necessary? And you think about the standard of necessity that the OIPC has developed through the case law. And it's not a standard of like whether this is an impossible initiative, but like it's more of it really boils down to, again, a reasonableness assessment. So is it like reasonable to like, and when you're assessing reasonableness, it's always helpful to think about it in terms of asking the question, how can I do this in the most least invasive way possible? Surely there's a lesser invasive way to get the things done that you need to get done without putting somebody's personal information through an AI model. You can justify it through other ways. You really have to justify the reasonableness of this decision. And again, same in the private sector. In order to do that, it comes down to assessing the vendor and the security safeguards, the amount of data, and AI models run on a ton of data. So whatever you could do to limit that when you're negotiating with third parties. I don't know if should I keep going with third parties or?
Sure, yeah.
I'll let Jen jump in.
Yeah.
Sure. I mean, sorry, we're thinking about like the risk assessment.
The risk assessment of personal information.
I think for me, this is where things seem really scary. Like we were talking about this earlier. I think a lot of us as lawyers are trained to think about all of the unintended consequences of something or recognize the fact that we don't know what we don't know. And the topic of AI deployment and how the technology works is so complicated and dense that sometimes at work, I feel like I need a PhD in computer science and symbolic systems and like a million other things just to understand how the tool is working. I think the good news is that the vast majority of the time, it's a pretty simple set of principles that we need to apply. And that applies both in like the privacy realm as well as AI governance. A lot of the legislation and the expectations that are put out by different governing bodies around the world basically boil down to like, are you causing people harm by what you're doing? And are you using only the limited amount of information that you truly need to give them the value they expect? Or are you like secretly, silently doing other things too and don't do that? So like it's not, I don't mean to oversimplify, but I don't think it's actually that hard if you think about it from that perspective. And you know, in terms of how that relates to like risk assessments, like in-house or with third-party vendor tools, I think a lot of it boils down to like, how confident are you that what is being communicated at the point of collection or the point of data ingestion is true to what's happening behind the scenes? And establishing that confidence is actually very hard. You know, obviously big technology companies are very distributed. You know, information silos exist in any large organization, and it's very easy for the left hand not to talk to the right hand. And all of a sudden you don't realize that that data is being accessed for model training that was originally collected, you know, to download a white paper or something on the website. So it's really how you establish that amount of trust and how you validate or verify that level of trust in a vendor. I feel like you were saying something else that I wanted to comment on about that.
We could talk about PIAs.
Yeah. Okay.
Always,
Yeah.
well, it's always good to start like with a PIA. In the private sector, it's not required in BC. In the public sector, it is, but it's still recommended by the OIPC anytime you're introducing new technology. And they've also have algorithmic impact assessments now that takes it the next level. And these are templates you can find on the internet that really forces you to go through the exercise of like, what are we collecting? What security safeguards are in place? How long is this retained for? What is it being used for? Is the use consistent with the reason that you're collecting it? Are you providing notice? Are people, you know, aware? Something that I always return to in my career when I'm advising people and how to deal with their employees and with clients is to ask, you know, or to remind yourself that people make complaints when they're surprised. So when you're transparent about what's going on and people know that their data is being used in this way, then that can help decrease complaints. So transparency is a big thing. Another thing for vendors is to look out for, like when you're negotiating service agreements, I always look to see if there's language about de-identifying data, because people seem to think that that kind of absolves you because when data is de-identified, it's not personal information at that point. But really be careful through the mosaic effect, and because there's so much data, it can all be combined to actually put together personal information. So there's no legal definition in BC of like what de-identified data is. So really drill down, like how is it de-identified? Are the keys to re-identify this, like, are they destroyed? Is there any possibility of this being put back together? Like when somebody has that in a contract, I always ask very specific questions about that process, because it would be contrary to privacy obligations to allow data collected for one purpose and what you're telling people for it to be used to train a model or used for all these other purposes. So that's kind of always a red flag for me when I'm reviewing vendor agreements.
I think that's really good. The point about transparency in particular, and different types of laws around the world have different requirements around transparency. It might be, like you said, to do a risk assessment that you can then show if you're asked by a regulator, but it also could just be as simple as making sure your policy says what you're doing. And like I said earlier, that that's true to what's happening in real life. But I think, for me, it's interesting. In my job right now, I work at Superhuman, formerly known as Grammarly. Actually, when I worked at Atlassian, my team was responsible for reviewing the procurement agreement with Grammarly. And actually, Grammarly didn't pass procurement because when we looked at like taking that big step back, thinking from a principled perspective, what Grammarly was asking to do was look at everything all of our employees were writing, anywhere that they were writing on any surface. And they were doing that to help with spell checking. And when we looked at that from like a proportionality basis, we were like, this doesn't make any sense. Why would we give this company access to everything in order to achieve like limited value? Let's be honest. And I think that thinking again on that principle basis, now that we are called Superhuman, we have far fewer problems with those procurement conversations because we are providing a connected network of AI agents that like execute your work for you. So we need to know what you're working on, who you're working with, how you communicate with those people, where you're communicating with them. So our customers expect that we have that wide aperture of information and they're comfortable with a pretty broad array of use cases because that's the value proposition of the tool. So I think, thinking backwards from that, in thinking about risk assessments, a lot of it is like, what is the value you're trying to accomplish? Does the aperture and does the access match that value? And what are some of the fundamental things that you need from that service provider or from your team to get you comfortable with that aperture, whatever it is? And so I think the questions that you asked are a really good place to start. And just to piggyback off of one of your ideas, I think the lowest hanging fruit to me is people using a word of art that seems incorrectly used, which is unfortunately common in the privacy sphere. If people say the data is anonymized, run.
Oh,
Like
totally.
that is a word that has a very special meaning and it has this very special standard that you have to meet that's almost impossible.
Never achieved.
It's never possible to be achieved for the most part. And that is like point one where I'm like, this is not going to be a good relationship. And de-identified is like number two. It's like, what do you mean by that? Because that actually doesn't have a legal definition. So there are just some things that you can do to start to grab that context that you may need.
Thank you. So we've talked a lot about data, and I think it's a great time now to shift to the questions. And the question that's not voted the most really asks about data, but in particular data loss. And so maybe we can ask both of you, whether within your company or your firm, how do you deal with data loss due to AI? So for instance, employees that put sensitive data into ChatGPT.
I mean, at least at my firm, if we became aware that somebody put personal information into something like ChatGPT, I would have to treat that as a privacy breach. And then we'd really have to think about whether there are reporting obligations in that respect. But as far as mitigating the chance of that happening, like we have at my firm, we have an AI policy that's very clear about the parameters, about the use of AI. We have paid programs that don't allow the model to train our internal data, but even with those, we still do not permit personal information to be input into those. And so I would recommend a policy for sure if you are permitting any type of AI use in your firms. Your associates, it's so tempting for students and associates to use it, and they don't yet have the knowledge developed to discern what's correct and what's not, and they're panicking, it's late, they're working long hours. It's so tempting, and so get ahead of it by putting a policy in place.
Yeah, similarly, we have a policy. I think working at a company that builds AI tools, we actually expect that people will put all manner of information into AI tools, including third-party tools. So for us, it's a conversation about what and when, not if. And we are not in the business of like patrolling everything that our employees are doing. We would spend all day doing that. So for us, what it actually takes is recognizing what are the tools of most value and setting up like business to business relationships with those companies. So we have our own enterprise version of ChatGPT that our security team has helped put controls within. We've created data use policies around, and we have ways of making sure that the right data goes into the right systems and not the wrong ones. So I think actually partnership can be really helpful for that.
Thank you. And the next question deals with teaching, which I know is something that both of you have done in different contexts. Michela, do you want to lead off on that one? So in terms of the lawyer's role or responsibility in teaching clients how to use AI to better interact with us and our services or to need us less. And then when we eventually do shift to an in-house perspective, maybe sort of kind of engaging with colleagues in terms of the teaching.
So this is a really interesting question because a case just came out in a decision in February from New York. And this is a good time to talk about privilege because there were reasons from the bench in the U.S. District Court in New York. And I have brought the case with me if anyone wants a copy of it after. And they granted an order for disclosure of documents related to queries made to an AI tool by a defendant in a criminal case prior to retaining counsel. And the court ruled that solicitor-client privilege did not apply to this. And the fact that the AI responses were provided to legal counsel later didn't mean that the original documentation is privileged. It'd be interesting, like if you were to advise a client to use AI and then they used it, like would privilege attach? Like it just like raises interesting issues. But what I took away from this case is that clients should be warned that if they use an AI tool, they are likely creating producible documentation. And so educating them about that and educating them about making sure that they don't put like your advice into an open algorithm, because if you look at the terms of service of these types of applications, they can use that data for whatever. They give it to third parties, they can train it, they can give it to government officials. And so it could be a waiver of privilege in that way. So educating your clients about the risks, I would start there. As far as using it, I don't know if I want to make myself obsolete. Like we would never become obsolete, but it's more about teaching them about the risks of using it. Like, and I never say don't use it, but I explaining the risks and how to do things in a compliant way and helping them develop policies and training and privacy awareness training and things like that. Yeah.
I love that. I think for us, I'm interested in the need us less piece the most, because when you work in-house, your most frequent clients are usually the people who need you the least. And then the people who don't come to you are the people that you want to talk to the most. So I like to spend most of my time getting the attention of the people who don't want to talk to me and less time with the people who want to talk to me all the time. And what I mean by that is like there's often really low risk, but frequently recurring requests that you get in-house. Like, can you review this marketing blog? The chances of us saying something in a marketing blog that are like illegal or gonna sewer the company are very low. But that team, they're very eager to make sure that they've gotten everything right and they, are good students, so they come to you all the time. So for needing us less, what I really like is coming up with like scalable playbooks. So I might use or work with my team to create a playbook leveraging some AI that helps them get like frequently asked questions in one place. So we might use AI to scan our system for past questions that they've asked in Slack or in email or in our knowledge base. We might use it to create a first draft of consolidating all of those questions on one page and grabbing answers that I've previously given from those sources under each question head. And obviously we look at them together. We make sure that everything looks accurate and correct. We also might ask AI and prompt it to say, like, what are other questions we should cover in this playbook? Would you differentiate the answers based on jurisdiction or geo? And then what we do is we also use other AI tools to plug directly into the channels of communication we have, like Slack, where a robot answers the question based on the playbook. So you can go into a legal help channel internally at our company right now and ask a question, and the chatbot will pull the answer from the vetted resource right where the person's asking the question, and I don't need to get involved. So I don't know that that's appropriate for every topic, but certainly for the lower value topics, it makes things work a lot faster. They get the answers that they need right away, and I get to focus on the things that have the most consequence for the company.
Thank you. So the next question is one that I've heard this come up in different contexts in terms of some of the concerns around in-house lawyers. So with the speed of AI adoption, what strategies do you use when talking with executives to ensure that legal doesn't end up being the department of no?
It's a you question.
I love this question. This is like the most frequently discussed thing in any in-house legal team. Thanks, Stephen. Yeah, I mean, when you are hired in-house, especially at a tech company, especially in the Bay Area, you are meant to be the department of yes, if. Hopefully you don't have clients who want to do illegal stuff. I think you should just quit if that's the case. It's much more comfortable to be in a company that has, some base level of interest and trust, but really you're there to help facilitate the business strategy. If you don't, people will just start ignoring you. And it's worse to be ignored than in the room and not listened to. So I guess like some strategies that I like to come up with are really reflecting back the business's priorities to themselves through the mirror of law. So if somebody wants to do something that I think might be at odds with what our customers expect, to Michela's earlier point, like it's sort of like an unexpected use case of data, I'll say, okay, I know that we have a company goal this year to grow our annual recurring revenue by X. We're specifically interested in this customer segment in education. How do you think they would react if we updated our privacy policy, which we will have to do, to say we're going to use their raw content from students for model training purposes? Do you think that our head of revenue might expect we will have some customers churn if we do that? So I think what's really important is to show that you share the target, like you are also a stakeholder who wants the company to succeed and is pointed at the top line objectives, and you are helping to get there by bringing in business considerations that they will care about. I think when you just parrot back legal stuff to people, their eyes glaze over, and that's not really their priority. Their priority is their goal, their objective. So I think it's important to communicate in that way.
Thank you. Are there any must-have AI clauses that you look to include in contracts with vendors?
Definitely.
Yeah.
Some of the ones that come to mind, compliance with all applicable privacy legislation, because your client is not off the hook for its own privacy obligations just because they give the data to a third party or they permit access to a third party to process data. Like, you still are responsible for that data and for your own compliance. So I always make sure that the vendor is going to comply with all applicable privacy legislation. Sometimes if they're more open, if they're not quite as large of a company, you can insert your own privacy schedule and refer back to that. Other times you kind of have to go, piece by piece through it and add what you need to add. But things that you should be adding include no secondary uses. Like, you're telling people that it's used for this, this, and this. It has to be consistent. They can't go and use it. You can't have function creep and use it for other reasons, because then you're falling offside of your obligations. So no secondary uses, reasonable security safeguards. There has to be sufficient data protection so that you can meet your own obligations in that respect. Controls on subcontractors, so making sure that you either have approval rights or that they are going to sign a confidentiality agreement, they are going to comply with all applicable laws. Like, anything that's applying to your vendor needs to trickle down to any subcontractor as well. And then staff should also, I always look for their own staff to have training and their own confidentiality agreements in place as well. Those are just some off the top of my head. Yeah.
I think those are all really great. I guess what I might layer in is similar to an approach that was taken early days in privacy law. It used to be that we would try to present only the permitted purposes of using our data. Like, you can only use it to provide the services as expressly provided in Exhibit A. And unfortunately, I think the world that we live in today would view that as anachronistic, because Exhibit A is going to become out of date overnight almost. Like, the technology is evolving so rapidly, trying to sort of hem a provider into one use case only will be rapidly not scalable. So I like to do the inverse. This was like a clever tactic I think privacy lawyers adopted pretty early on with GDPR, is like, say what they can't do. Maybe don't say only what they can do, because they're not going to like that and you're going to argue over it endlessly. But if you can say, specifically, this can't be trained, like Anthropic did with the US Department of Defense. You can't use it. You can't use Claude to attack people. And now we see that playing out pretty publicly in the media today. So similarly, I think we like to tell vendors what we're concerned about, and that makes the negotiations a lot faster too, because most of the time the things we don't want them to do are like evil things nobody should be doing, and it's pretty hard to be like, strike that. So I think that would be my biggest tip.
I think we probably have time for about one, maybe two more questions. And so I'd like to ask the question that Julian poses there, but fold it together with some other questions about, with some other considerations about how lawyers and just members of the public can also stay ahead. So as AI increasingly enters law, with job security a frequent topic of discussion at school nowadays, how can students stay ahead and better prepare for practice? How can lawyers stay ahead and better prepare? Are there certain resources that you might recommend for people that want to learn more about AI?
I think for law students right now, trust yourself and know that AI is not, it doesn't have the capabilities that you have. It doesn't have the discernment. There always has to be a human on the end operating it. At the end of the day, AI is a tool. It's not replacing, it'll never replace lawyers. It's a tool. And so think about it in that way, as a tool that can help you when used appropriately, and not as something that's going to detract from your career, but support your career.
I think that's right. And specifically, I think one way of thinking about that is to try to critique the output of AI yourself. Like, use it, because you will have to use it eventually in your career at this point in time if you're in school. So maybe practice using it and then look at the output and try to critique it. Like, what did it miss? What did it get wrong? Why do you think that might have been? Was it about the context or the prompt that you provided? Or is it maybe trained on information that you shouldn't be relying on? I think that will set you up to identify which tools are going to be most valuable in your arsenal as you proceed in your career, and how to figure out what is sort of going to give you the right result and the wrong result. The other thing that I was going to say is that, there was one other aspect that you asked about.
Well,
It's like using it and resources.
Yeah.
So there's a lot of podcasts that are really great and also free. If you're just generally curious about AI and like what's happening with AI, like, I would say Today Explained is a great podcast to look at. They often profile companies and, the use cases that they have going on. There's a sort of like an AI star in the legal world in the US called Anna Gressel. I think she recently left Paul Weiss for obvious reasons, and then I don't know where she landed, but she still has a podcast, and it's about AI in the law, and it's really great. Again, free. And Michela and I were talking about this earlier. We both actually weirdly follow a lot of people on LinkedIn, which I'm not normally like a social media person, but there are a lot of accounts. Like, each data protection authority seems to have its own LinkedIn account, and it will publish decisions and topics of interest. Similarly, there are bodies that are involved in AI governance. I'm a part of a group called AI 2030 that posts a lot on LinkedIn about responsible innovation in AI. So I would start with what's free. If anybody's trying to sell you something at this point, I don't think that's really necessary, especially for students.
Yeah, like LinkedIn is such a good resource. It's so easy. It's hard to keep up, especially in privacy law. There's new things happening all the time. And so, we all are nosy on Monday and seeing what's going on LinkedIn. So when you're scrolling LinkedIn on your break or whatever, if you follow enough of these, governing bodies and privacy authorities and regulators, you will get, the latest on that. So that's a good way to do it in kind of in a way that you're already going to scroll. So you might as well just have a few pop up that turn your mind to these issues.
I think this is taking us to the end of our time. Are there any final thoughts that either of you would like to make, just to wrap up your comments for today?
Do you want me to go?
You go.
Okay. I think my sort of thought I'd love to leave everybody with is just that the moment is here. Like, we are not in a moment where we are waiting to see if lawyers will use AI. Lawyers around the world are already using AI. And it's not a matter of whether you're going to use it, but how. I think that's a decision that we all need to make, according to our knowledge of our clients and our issues and the data that we handle. But I also want to share an invitation. Like, the privacy community by heritage is a very warm bar. We're a very open group of people. We compare notes a lot because we deal in a lot of gray, and we kind of like to all be in it together. And I think similarly for folks dealing with AI issues, many of us are the same people. We really welcome participation, would love to connect with you, and think through things together.
And I'll just end with a quick plug for the Law Society's practice resource guidance on professional responsibility and generative AI.
Nice.
Very good resource that you should, if you are using AI or you're thinking about it, please read this so that you are able to comply with your ethical and professional obligations.
Before we do wrap up, I want to say a big thank you to Jennifer Regan and to Paige McKenzie and to your teams for putting together this really wonderful event, and so thank you so much. The warm round of applause. And then also a really warm round of applause for our two speakers today. I learned so much from both. It was lovely just to see you both again. So thank you to Michela. Thank you to Jen as well. Yeah. Well, that wraps up our conversation for today. Thank you all for being here, and I look forward to seeing you again.